Good evening, friends. Amongst us, we have M. Karunanithi, advocate, who is a former member, Law Commission of India, special public prosecutor for CBI cases and High Court, and a senior Union of India panel counsel. We have done various sessions with him, and being the criminal jurisprudence's forte, we keep on requesting him to share his knowledge on this aspect. As we have seen, and as to how the forensic evidence has developed with the flux of time, therefore the interplay of role of forensic science, forensic evidence, in proving the crime is the journey of today. And thank you, Mr. Karunanithi, for accepting our invite, and over to you. Yeah.
Good evening, friends. Very nice meeting after a very long time. My sincere thanks for my friends for having given me this nice opportunity to meet the brothers and sisters across the country. So the topic is forensic medicine and its impact, or how the forensic medicine helps in crime detecting and proving the criminal case. As usual, I want to begin the session with a question. My question before this August gathering is whether forensic medicine is foreign to lawyers, or the forensic medicine is very close to us, whether it has been taught in the law colleges. My answer is forensic science and criminal law are inseparable twins. Forensic science is nothing but one side of the coin. So as lawyer practicing in the criminal side, we must know the nuances of forensic science also. Whether the forensic science plays an important role in proving the criminal case? Yes, no doubt at all. Forensic science in many ways helps the investigation to find out the truth, as well as it plays a vital role in criminal court, in criminal justice delivery system, to prove the charges leveled against the accused. No doubt, the investigation begins as soon as FIR is registered, investigation begins. We all know, as soon as charges are framed, criminal trial commences. The accused has been summoned. The plain reading of the summon will reveal that the accused has been summoned to answer a charge. So the charge is very, very material. Very, very material part of a criminal trial is framing of charges. Now the prosecution has to prove the charges beyond all reasonable doubt. No doubt, a facet of Article 21 is fair trial. So when investigation is fair, then only the criminal trial will be fair, no doubt at all. And it is for the prosecution to prove the charges, that too beyond all reasonable doubt. There are pattern of judgments, what is doubt and what is reasonable doubts. Very recently, by judgment dated 1/9/2025 in SLP Criminal 18377 of 2024, SLP Criminal 18377 of 2024, decided on 1st September 2025, the Honorable Supreme Court came to a conclusion and given a very, very elaborate judgment and in a POSCO case. And in that judgment, the Honorable Supreme Court categorically stated that it is not all the doubts which the accused is entitled to, and it is only a reasonable doubt. It is only a reasonable doubt. There are many judgments on this point earlier also. So we are following the theory that the prosecution has to prove the charges beyond all reasonable doubt. The shoulders of prosecution is heavily burdened. We follow the English law that the prosecution has to prove the charges beyond all reasonable doubt. In Wilmington versus Director of Public Prosecutor, 1935 AC 462, and Miller versus Minister of Pensions, 1947, Volume 2, All English Reporter, page number 372, speaks about reasonable doubt and theory of proof by the prosecution. By judgment of Honorable Supreme Court reported in AIR 1979 Supreme Court, page 387, K. Gopal Reddy versus State of Andhra Pradesh. K. Gopal Reddy versus State of Andhra Pradesh, AIR 1979 Supreme Court, page 387. And AIR 1974 Supreme Court, page 156, K. Karan and others versus State of UP. By these two judgments, the theory of benefit of doubt has been recognized by court in India. Thus, we are clear that the prosecution has to prove the charges beyond all reasonable doubt. And very recently, Honorable Supreme Court in SLP number 18377 and Criminal Appeal number 3813 of 2025. 3813 of 2025 came down and categorically stated what are all the doubts and what are all the benefit of doubt. For example, if a witness is not able to give a time exactly, this will not give benefit of doubt. This will not be a doubt. But when a doubt is fundamental, then only the benefit of doubt can be extended in favor of the accused. So, as we all know, as per section 2H of CRPC, collection of all evidence is the investigation. So during the collection of evidence and during the trial, the forensic science plays important role. For example, in order to prove the even simple injury, grievous injury, to prove the age, to prove the identity of a person, either through DNA test or through superimposition test, and to prove the cause of death, handwriting test, to prove fingerprints, and to prove gunshot injuries. Medical science helps the prosecution when accused is not known. The accused is not known. By collection of materials available in the scene of crime, even a hair is sufficient to identify the perpetrator of the crime, as well the identity of the body of the deceased, identity of the person deceased. So there are three major systems responsible for the systemic functioning of the human body. As lawyer, we must know the elements of human anatomy. There are three major systems responsible for the systemic functioning of the human body. The first one is nervous system. Nervous system, brain is the head of the nervous system. The second one is circulatory system, heart is the head. The third one is respiratory system, lungs is the head. Besides the above three systems, other systems like digestive system are also responsible for the proper functioning of the human body. For example, let us take a case of 302 case of murder. Whether the forensic science is helpful to prove the injuries. We all know immediate after the registration of first information report, the investigation officer will lift the body of the deceased with a letter of requisition to conduct postmortem on the body of the deceased. Apparently, there are many number of injuries found on the body of the deceased. Still, the body is lifted to the doctor for the purpose of to find out the cause of death. Sometime just after seeing the weapon, lethal weapon, death would have occurred due to heart attack or neurogenic shock. Death may be due to loss of blood. Death may be due to heart attack. Death may be due to neurogenic shock. We all know heart attack, but a very, very crucial attack that is known as neurogenic shock. Neurogenic shock means a shock which gives instantaneous death, which gives death instantaneously. I was a prosecutor in my native place. My case is death was due to neurogenic shock, and the deceased gave a oral dying declaration to PW1. With only one question to the autopsy doctor, I lost my case. The Learned Defense Counsel put a question: what is neurogenic shock? Whether after, as soon as neurogenic shock, whether the person can communicate? No. This is the answer. Death is instantaneous. So the plea of the prosecution that the deceased gave a oral dying declaration was negative. Now the point is, forensic medicine, forensic evidence is before the court. Whether the evidence of forensic officers, expert evidence, can be taken into account fully, and what is the character of the expert evidence. Let us go through section 45 of Indian Evidence Act. Who can give evidence? Section 118 and 119 of Indian Evidence Act will speak volume. Section 118 and 119 of Indian Evidence Act will speak volume. Let us, for the purpose of the topic, let us take section 45 of Indian Evidence. Opinion of expert. So the topic is very, very clear. It is only an opinion. It is only an opinion. When the court has to form an opinion upon a point of foreign law or of science or art or as to identity of handwriting or finger impressions, the opinions upon the point of persons specially skilled in such a foreign law, science or art, or in questions as to identity of handwriting or finger impressions or relevant facts. So the key word is persons specially killed. So the topic gives a idea about the character of the evidence witness. It is only an opinion. It is only an opinion. Before going to the topic in depth, let me read paragraph 32 of the judgment of the Honorable Madras High Court in A. Muthupandi versus State. In A. Muthupandi versus State. The judgment is very, very important. That is why we have chosen this topic. Let me read para 32 of the judgment. This is a case of sexual assault. The judgment speaks about the importance of cross-examination and the necessity of the lawyer to go through to get some idea about human anatomy also. Paragraph 32, learned judge came down so heavily. Let me read. At this juncture, this court has to necessarily record its displeasure in the manner in which the witnesses are cross-examined on a daily basis. This court is able to find that the standard of cross-examination of witnesses has gone drastically. It is quite unfortunate that the trial court advocates are not developing their skills of cross-examination. Most of the questions which are put to the witnesses are irrelevant and illogical. Irrelevant and illogical. The trial court advocate must bear in mind that they are defending the right of a person guaranteed under Article 21 of the Constitution of India. Hence, it is their bounden duty to put appropriate questions during the cross-examination, failing which their client will lose his or her liberty by suffering a sentence. The art of cross-examination was considered as a crown in advocacy skills. If this art is lost, the charm in conducting a trial before a court will also be lost. Why I have chosen this topic is the not only in this judgment, in many cases, even in another case, Division Bench of Madras High Court came down heavily when a doctor who admitted a person sustained some injuries was cross-examined days together. The name of the college, whether you have been selected, merit, which quota, and so many questions irrelevant to the case, irrelevant to the charges, irrelevant to the evidence given in chief. So after a full day, the witness was stopped and he was called again for further cross-examination. So there are many cases. No doubt, forensic science has not been taught in law colleges. But nevertheless, it is our bounden duty to go through the papers and to prepare well with the help of a doctor. What question is to be asked? What question ought not to be put to the doctor? At many times, I used to try to appear in session style in various parts of Tamil Nadu. At many times, I said, no cross. So, learned members has to prepare in civil cases, drafting of plaint, drafting of written statement. The members of Bharas Bar will take many days to prepare plaint and to prepare written statement. So pleading is very, very essential in civil law. So also in criminal law, cross-examination is very, very essential. So in a major trial like murder and POSCO cases, rape cases, we have to go through the documents twice or thrice and we have to get opinion from doctors. And then only we have to prepare whether we have to come to a conclusion whether cross-examination is to be made or not. Yes, the death, let us take a case of murder. Death takes place. A committed murder of B. What is death? It has not been defined. It has not been defined. Immediate after the death, there are three major changes will occur. Immediately, there will be a stoppage of function of nervous system. Nervous system will stop. Respiratory system will stop functioning. As well, circulatory system will stop functioning. Somatic death. It is not a somatic death. only thereafter there will be a cellular death. Only thereafter cellular death. When we go through the postmortem certificate, the doctor used to record rigor mortis present all over the body or in some places. What is meant by rigor mortis? Rigor mortis, the stiffness of the body. Rigor mortis is the chemical changes in the body. Rigor mortis is the chemical changes. ATP, generally medical people define it as ATP changes. Postmortem stiffening of muscles that occurs after death due to lack of oxygen and the depletion of ATP, preventing muscle fibers from relaxing. Immediate after somatic death, 230 hours or 3 hours, the rigor mortis will begin. Voluntary muscles, and there are known as voluntary muscles and involuntary muscles. It will begin in eyelids and slowly upwards in the face and then other parts. And after 3 hours, after 48 hours, so to begin 3 hours and it will complete 48 hours, so 51 years, hours it will take to rigor mortis to present and set off. So to find out the time of death, what was present in the stomach? Food particles. We have to get some instruction from the client, and we have to go through the evidence of eyewitnesses and the postmortem report, whether stomach contains semi-digested food or digested food or undigested food. We have to get some inputs. Normally 3 hours will be for complete digestion. So with all these points, we have to cross-examine the eyewitnesses. Man will lie, but science will not lie. So keeping in mind, we have to prepare a notes before cross-examining the eyewitnesses account. Okay. In a case of, it was a circumstantial evidence case. In this case, PW1 claims that he had seen the deceased and accused, and thereafter in the next day morning, the body was found in the lake. According to PW1, the accused and deceased was last seen on the day, then the very next day, morning itself, the body was found near the place. So body was forwarded to doctor to conduct autopsy. As per the postmortem certificate, brain was liquefied. The trial was conducted before the Sessions Court at Tanjavur in Tamil Nadu. It ended in conviction, life sentence was awarded. When the division bench of Madurai bench of Madras High Court, Honorable Mr. Justice S. Nagamuthu, the learned senior counsel in the Supreme Court, appeared as he then was. As a lawyer, he addressed. He took less than a minute, and the division bench was pleased to allow the appeal, and the accused was acquitted. The only point raised before the Honorable Division bench is there was no material except the PW1. On the strength of last seen theory, the accused was found guilty and convicted. The evidence of PW1, the last seen theory, has to be rejected because as per the postmortem certificate, brain was liquefied. The brain will get liquefied only after 3 days. On hearing this point and on going through the postmortem certificate, immediately the division bench came to a conclusion that the prosecution has miserably failed to prove the charges and acquittal was recorded. So before going through before going to cross-examination, we must be clear how not to cross-examine. Whether cross-examination is necessary or not, we have to say. Very recently, in a case of accidental claim, civil miscellaneous appeal, the Honorable Supreme Court was pleased to dismiss the appeal filed by the claimant. It was a case of simple injury, and thereafter he developed some pain and other things. He was then admitted in the hospital. It's a case of Hasina and others versus the United India Insurance Company Limited and another. Civil appeal number 6621 of 2025. Civil appeal number 6621 of 2025. It's a very recent judgment of the Honorable Supreme Court. Decided on September 4, 2025. The doctor who had treated the patient was examined as PW1. There was no nexus between the injury suffered and the death. There was no nexus between the injuries suffered and death. There was a fracture on the right finger, and so in the skin grafting at the local hospital, and a surgical procedure was also done by plastic surgeon attached to the higher medical center. Operation was success, but patient died. It was a case after the occurrence. The person developed some injuries, some pain after 6 months. The further surgery was done and he died on the date immediately. That is, there is a time gap of 6 months between the date of occurrence and he succumbed to injuries. As per the evidence of a postmortem doctor, there was no nexus between the injury and the death. He died out of cardiac arrest. Definitely, prosecution could have filed an final report for the offence under section 304A of capital A of Indian Penal Code. If it is a case of 304 capital A or any other case, there must be nexus between the injury and death. There must be nexus between the injury and death. So, holding that point, the civil appeal was dismissed by the Honorable Supreme Court. Civil appeal was dismissed by the Honorable Supreme Court. Let us take, for example, death by burn injuries, death by loss of blood, death by burn injuries, death by poison, and there are several matters. For example, let us take death by burn injuries. Very quite common. There are final report for the offence under section 302 IPC and 304 capital B of Indian Penal Code also. There are 3 categories of burn injuries: first degree, second degree, and third degree. Third degree burn injuries. Third degree burn injuries. So in first 2 degrees burn injuries, pain will be more. Pain will be more. The entire body, human, as per human anatomy, our body has been controlled by, as I already told, nervous system. Brain is the head. Central nervous system controls our body. Central nervous system. So, if a person sustained first degree and second degree burn injuries, pain will be more. So, definitely painkiller like pethidine injection used to be administered. So, before conducting the criminal trial, if it is a case of burn injuries, we must go through the bed ticket or hair sheet. In Tamil Nadu, we used to say it is a case records, case sheet maintained by the hospital. We have to summon it, we have to go through it. At many times, if patient is admitted in the hospital as an inpatient, the doctor will record it in document known as accidental register. Accident register in Tamil Nadu. In some state, it will be called in by another name. But as far as the injury is concerned, the doctor who admits the patient is an eyewitness. He sees the injuries sustained and he is to record where and by whom the injury sustained. Who brought the person sustained to the hospital also will be recorded in the accident register. Insofar as the other entries are concerned, it is only a hearsay. But simply because it is a hearsay, we cannot ignore it. At the time of argument, at the time of cross-examining the witnesses, we must keep in mind the entries made in the accident register. In a case decided by the Division Bench of Madras High Court, in the accident register, it was recorded that the assault was made by unknown persons. By using white paint, a UN was deleted by using white paint. So the learned counsel before the trial court placed the accident register before the investigating officer and he got an answer. And there was, UN was erased by using white paint, and the learned judge also in the division bench by using using the glass lens found that there was something wrong. Murali Sami alias Muralidharan case, very famous case. It was ended in acquittal. In case of injury and the patient is alive, treatment is going on, definitely die-in declaration will be recorded. Learned magistrate used to record the die-in declaration. So we must be careful enough. We must be careful enough to conduct the trial. So before cross-examining the witnesses, some person claims I had seen the occurrence. So we have to go through the medical records so carefully. If before recording the die-in declaration, if some drugs are administered for the purpose of lowering the pain, like pethidine, it is not available now. Some other medicines are administered in the government hospitals, but the central nervous system will be affected. Central nervous system will be affected. So we have to raise from the mouth of the doctor what type of injury, whether it is a first degree burn injuries or second degree burn injuries. In first degree and second degree burn injuries, it is a superficial injuries. So pain will be more and all nerves are available. If there is a injury, definitely pain will be more. That is why some drugs have been administered, and we have to go through the case records and we have to get positive answer from the doctor. And in some cases, death due to septicemia, injury will be there. The patient was very much available in the hospital for quite long time, but after some time, death due to septicemia. In such a cases, the question will be, no doubt, on going through the evidences available on record, no doubt the accused have committed the offense. The court may come to a conclusion. There are positive evidence and he only participated, he is the perpetrator of the crime. He had committed the offense. Another question would be, for what offense he is liable to be convicted? For what offense he is liable to be convicted is a bigger question. In case of a septicemia, right from 1943, Doraiswamy Servai versus Emperor, 1943 Madras Weekly Notes Criminal page 185. B.N. Kavatkar versus Karnataka, State of Karnataka, 1994 SEC Criminal page 579. And very recently 2023 volume 1 MLJ Criminal page number 46. Pasungli versus State. Pasungli versus State. How the medical evidence has to be appreciated, these three judgments will guide us. And very recently, the Honorable Supreme Court came down heavily. In so far as this septicemia case was converted into (307). And regarding the septicemia case in Pasungli versus State 2023 Madras Law Journal Criminal, in paragraph 41, learned judge gave 3 illustrations. In paragraph 41, learned judge gave 3 illustrations and 42 gave explanation. So, for beginners, we must go through para 41 and 42 of the Division Bench judgment of Madras High Court at Madurai Bench. The author of the judgment, Honorable Justice J. Nishabana and Justice N. Anand Venkatesh. Conviction was altered from 302 IPC to 304 Part 1 of IPC. 10 years imprisonment was given. When the conviction can be reduced to altered to 326, when the conviction by 302 is sustainable, when it can be reduced to 304 Part 1 of Indian Penal Code, the judgment of Madras High Court in Pasungli case will give light to us. And very recently, Honorable Supreme Court in a given case altered the case 1 under section 307. I asked my learned brother to share the list of judgments also, and I expect my friend will immediately share the judgments for the welfare of my learned brothers and sisters. And I already said allow my friend, he will share the MS Parthipan, he also joined. He will share the slide, shows the judgments. I already discussed. The forensic science will help to find out the time of death. The very recent judgment, 2024, 8 SEC page number 149. 2024 volume 8 SEC page number 149. Babu Saheb versus State of Karnataka. Babu Saheb versus State of Karnataka. Before making cross-examination, cross-examining the investigating officer, we must know very recently Honorable Supreme Court came down heavily how to contradict a witness. Very elaborate judgment of the Honorable Supreme Court. And we must know there are 2 types of diaries in the criminal law. One is station diary, general diary and case diary. In the Babu Saheb versus State of Karnataka, paragraph 48 to 50 speaks about the diaries, speaks about the diary entries. And in paragraph 53, the Honorable Supreme Court elaborately given the verdict regarding the time of occurrence. The time of occurrence as spoken to by the witnesses has not been supported by medical evidence. As per ocular version, incident happened at 4 p.m. on 19/9/2001. Medical jurists deposed that the dead body of the deceased was in a stage of decomposition. As I have already stated in a case decided by the Madurai Bench of Madras High Court. On the very next day, the brain was liquefied. So the prosecution theory was disbelieved and the accused was acquitted. Very recently, according to the evidence of ocular witness, on 19/9/2001 by 4 p.m., the occurrence took place, according to the witnesses. But as per the medical evidence, body was in a stage of decomposition. Body was in a stage of decomposition. So the age of injury. So this is a case we can say, as per section 45 of Indian Evidence Act, it is only an expert, it is only opinion. The forensics and doctor's evidence, it's only opinion, it is only advisory in nature, it is not a substantive piece of evidence. We cannot rely upon totally on the evidence of doctor, no doubt at all. When conflict is there between the ocular evidence and the medical evidence, there is no straitjacket formula that medical evidence has to be rejected. As well, there is no straitjacket formula that the eyewitness account has to be rejected. So it has to be cumulatively considered. In case of in Babu versus state of Karnataka, the evidence of injured the eyewitnesses and the forensic evidence was taken into consideration. When the ocular evidence is apparently found some material discrepancies, then it cannot be relied upon. In the given case, decomposition started. After 51 hours only, rigor mortis will set off and decomposition will start. The immediate after death, what will happen? There are three changes. The changes in the eye, changes in the skin. Some lawyers might know the doctor will use, by using the torch, they will switch on light in the eyes only. There will be no reflection. It is a symptom that somatic death happened. So there will be a change in the eyes. There will be changes in skin, changes in body fluid, and late changes after death is putrefaction or decomposition. We the members of the bar are at least to arrange a class by a doctor. Even in many hospitals, there is no expert in the field of forensic science. Other doctors used to conduct postmortem, and the eminent doctor who had given whose book is very material on the topic, The Essential of Forensic Medicine and Toxicology, Mr. K.S. Narayan Reddy and Murthy. This is a textbook in all medical colleges, and the author opined that do not underestimate the medical knowledge of a lawyer. This was given to all doctors. But after going through the Muthupandi's case, and there was a direction to the leaders of the Bar Association to take class. And we must be careful enough before preparing for trial, as followed by lawyers who are doing civil cases. Before preparing, framing of case is very, very important. Framing of case is very, very important, even for a suit for bare injunction. My senior used to call the clients to get some documents, to get other documents. He used to say, sir, many times he used to have some discussion with the clients. And after going through all the documents, sometimes illiterate people may not know the value of a document. Very, very important document they used to keep in their home. So many sitting must be there, and only after going through the papers, only after going through the documents, we must be able to frame a case, even for a suit for bare injunction. So, like the same, even to conduct a case under sections 324 or 323 IPC, we must be careful enough. We must be careful enough before cross-examining the doctors, So, in many ways, for example, DNA test. We may say DNA test is a foolproof test, 100% result test. But if there are some mistakes in taking blood samples, the result may not be accurate. It is not an accurate test. It is not an accurate test. We have to get some inputs from the doctors. When the result in a DNA profiling test is not accurate, so we have to cross-examine on those lines how sample was obtained, where the sample was obtained, by whom the sample was taken. These are all points before accepting the DNA profiling test. Like the same in fingerprint test and other test, we have to go through the basic things as per the textbook. Another question I got, my own doubt. If a doctor gives a evidence that opinion is contra to the opinion expressed by a famous author in a book, whether the book has to be noticed or the particular area has to be given to knowledge of the particular witness, or we can simply suggest. No doubt, the author has maybe a expert, maybe a senior most person. It is only his opinion. But before confronting to the witness, we must bring the book. We must bring the attention of witness that so-and-so is an author. He has authored a book and this is his opinion. But you have given opinion contra to this. How you have given this contra opinion? Unless there is such a suggestion, unless we notice the opinion given in the textbook, simply because we put some suggestion, it cannot be taken into consideration by the courts. Cannot be taken into consideration by the courts. Death by burn injuries, death by shock and hemorrhage is very, very common. And in a judgment reported in 1994 SEC criminal, Megaraj Singh versus State, no doubt the prosecution, very base of the prosecution will be either it is a case under section 323 or 302 of Indian Penal Code. First information report is the base. If first information report is doubtful, if we cannot rely upon first information report, then the entire construction on such an FIR would definitely fall into ground. How to doubt the FIR? How to doubt the veracity of the FIR? Anti-time FIR. So in Meghra Singh case, guideline have been given by the Honorable Supreme Court. Whether the first information report, a copy of the report has been forwarded along with requisition to conduct post-mortem. Whether there is a delay, these are all the 2 points, the external check to come to a conclusion whether FIR is anti-timed or not. Whether FIR is anti-time or not. In general, in case of a murder, culpable homicide amounting to murder, culpable homicide not amounting to murder. So if there are materials, both oral and documentary, to show that A has assaulted him, no doubt he committed the murder, he committed the injury, he caused that injury. What offense he has committed, for what offense the accused is to be convicted, by referring to the medical evidence. This may be for the offense under section 302 of Penal Code, or even 323, even 323 also, part 1, part 2, 326, for the lesser offenses also. We have to go through the medical records and prepare well to get success. We must know which weapon will cause particular type of injuries. Blunt weapon. Before cross-examining, we must go through the weapon. Blunt weapon, incised injury, simple injury and grievous injury generally will know. But whether it is a cut injury, Arwal cannot make stab injury. So we must know the difference of different kinds of injury. Different kinds of injury. By this lecture, I request the leaders of the bar, as held in A. Muthupandi's case, let us call some senior doctors and forensic science to give lecture on the topic of forensic medicine and toxicology, to improve our medical knowledge and to conduct the criminal case so effectively. With these few words, I conclude. I will put, sir, type in. In the chat box, I will give the judgments which I have referred to. I have referred 16 judgments, but for want of time, I could not read the relevant portions.
You can share it with us. We share it on the this thing, YouTube link, as well as you can also share it on our website.
Yes, sir.
Yeah.
Sir, if you permit,
have
Mr.
permitted-
Parthiban is online. Yep,
I am-
Parthiban.
I am-
Mr. M.S. Parthiban.
We have permitted the
Yep.
screen sharing.
He will share the slide also.
Which by which name?
We right now, sir, he will forward.
Whom I have to allow this screen sharing? Which lawyer?
Yes, sir.
Which lawyer I have to allow the screen sharing?
Yes, sir.
Yeah.
Sir, correct, sir.
Yeah.
Sir, now he is sharing, sir.
Yes.
And yet another judgment, Devendra Singh and others versus State of Uttarakhand. Devendra Singh and others versus State of Uttarakhand. 2022, volume 13, SEC, page number 82.
Just tell him to hold the screen for some time. So
Yes, sir, we will hold it, sir. We will hold it, sir.
Yeah. They can have a screenshot
So
of that.
so that. In Devendra Singh and others versus State of Uttarakhand, reported in 2022, volume 13, SEC, page number 82. Charge was under section 304B of Indian Penal Code. Whether drowning, it's a case of drowning, deceased found dead in river, cause of her death, whether accidental falling into river or not, it was decided that no water was found inside lungs and abdomen of the deceased. Paragraph 24 is relevant. Paragraph 24 is relevant. These 6 judgments also very important. And yet another judgment from Supreme Court, 2018, volume 2, Madras Weekly Notes, criminal, page 341, Supreme Court. Rupender Singh Sandhu versus State of Punjab. Rupender Singh Sandhu versus State of Punjab. During trial, we should not invite problems by putting some question to the witnesses. Keeping silence is very, very nice art of cross-examination to my knowledge. In this case, no opinion, the decided case by the Honorable Supreme Court, no opinion as to cause of death given by PW2 postmortem doctor. And we used to say, doctor will give evidence. These injuries are sufficient in the ordinary course of nature to cause death, which is very, 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 very essential. Ante-mortem injuries and post-mortem injuries. Ante-mortem injuries and post-mortem injuries. To find out whether injury is ante-mortem or post-mortem, the doctor ought to have conducted a histopathological examination. Histopathological examination. If it is very, very useful in case of circumstantial evidence. In case of circumstantial evidence, there may be putrefaction after the dead body is found. The identity of the deceased, identity will be fixed by superimposition test. By superimposition test. In Tamil Nadu, an application under section 482 CRPC was filed before the Honorable Madurai Bench of Madras High Court. Elaborate inquiry was conducted and the judgment of the trial court was achieved. This is also a reported judgment authored by Honorable Mr. Justice S. Nagamuthu. In that case also, in the decided case also, superimposition test was conducted. But the author, Mr. K.S. Narayan Reddy, recorded that it is not an accurate test. So we must go through all the medical records and other records collected during investigation and to cross-examination only after thorough preparation. Then only we must have some reasonable doubt, and then only reasonable doubt, we will endure that reasonable doubt, the benefit will be given to the accused. Contradiction between the medical evidence and eyewitnesses. Important judgment of the Honorable Supreme Court, 2019, Volume 1 SEC Criminal, 2019, Volume 1 SEC Criminal, page number 319, Mallikarjun and others versus State of Karnataka. To find out postmortem injuries, antemortem injuries, the doctor has to conduct a histopathological examination. And we must prepare in such a way, then only we can do fair trial. We must be fair in preparing our case. With this, I conclude my sincere thanks to all the members and for having given me this nice opportunity. My sincere thanks. Dhanyavad.
Thank you, Mr. Karunanithi. You have
Welcome.
taken us to a journey of law with a deeper dive as usual. And those who want to watch it, the earlier sessions done by Mr. Karunanithi or any other speaker, you can log into the channel of Beyond Law CLC. Thank you, everyone. Stay